Next, this spring, some ethanol producers sent letters to Nebraska corn producers telling them not to deliver their contracted corn due to force majeure. So, what does that mean, and how does it relate to agricultural contracts? UNL Extension Water and Agricultural Law Specialist Dave Aiken joined me to break it all down.
Well, force majeure literally means superior force, and it is a rule in contract law that lets people get out of contracts in very rare instances where unseen forces outside the control of any of the parties make contract performance impossible or impractical.
What are some examples of force majeure events?
Well, floods, droughts, hurricanes, tornadoes, volcano eruptions, lightning strikes, and those types of natural catastrophes are typical force majeure events. They're also called acts of God, and I think people are probably more familiar with that, nomenclature. But there are additional force majeure events that are outside of this natural catastrophe group, and that includes war, labor strikes, riots, civil unrest, and any government action making contract compliance illegal, impossible, or impractical.
And I noticed with all those examples that you mentioned, you didn't have pandemics on the list. Are those included?
They used to be on the standard list of natural catastrophes or acts of God. Now, because of the improved medical technology that we have, they're much more infrequent. Some people still have them in their contracts, but a lot of people don't. They sort of dropped off because they haven't happened very often. But I don't think there's any doubt that they still qualify as a force majeure event.
So when a force majeure event happens, break down what the process is.
Okay, well, the party who thinks that a force majeure event has occurred notifies the other party that the contract needs to be put on hold, at least for the duration of the force majeure event, or maybe even canceled altogether. If the other party disagrees and they can't, get together on some compromise, then they can go to court to get the judge's ruling on whether force majeure applies to their situation or not. So this would be the ethanol plant saying, we can't use your corn, force majeure, and they talk and say, well, do you want me to just hold on to it until you're ready for it, or do you want me to just go ahead and make the best deal I can, and what? And they have that discussion, and hopefully the farmer gets clarification on whether the ethanol company says no, hold it, and we'll pay. It just may be a few months down the road. We don't know when, or they may say no, we're not going to be able to use it. Period, and that you've got to do the best you can with it.
And Dave, what was the chain of events justifying the ethanol plants canceling corn purchases?
It is a chain of events. We've got the COVID-19 pandemic, and then that led to the stay-at-home orders, kind of across the country. And that, in turn, led to a dramatic drop in people driving their cars or trucks or whatever, over 70% drop in miles driven during March. At the lowest point, we dropped 50% in ethanol production in the United States. And again, that was in that low point in March. Now we're back up to 80%, so we're not out of the woods, but we're heading in the right direction.
So what happens if the contract doesn't have a force majeure clause?
Well, in Nebraska, the courts have recognized both acts of God and something called Section 261 of the Restatement of Contracts, which basically have the same effect as the force majeure. So it's not called force majeure, but the law itself is pretty darn close.
And Dave, does the mere occurrence of some force majeure event allow one party to cancel a contract with a force majeure clause?
No, and that's an important thing to understand. Just because we've had the pandemic, or just because there's been a flood, or just because there's been a tornado, that doesn't mean that all the contracts are canceled. Whatever happened, that event that nobody anticipated but came in and is wrecking everything, messing everything up, that has to mess up the contract. If it doesn't mess up the contract, then even though it's a force majeure event, that doesn't give anybody the right to just jump out of the contract because they don't want to do it anymore. So in the ethanol plant situation, if the pandemic had only resulted in a 5% reduction in driving or gasoline sales or something like that, just the fact that there's a pandemic wouldn't justify claiming force majeure, because 5% up or down is well within the normal market gyrations, and so that would not end up being a force majeure event.